Hello. Hello.
Very good afternoon, dear presidents and members of the district commission. Today there is a slight change in the schedule. So we'll have Dr. Kantikar first speak on Medical Negligence and Consumer Protection Act, followed by Dr. Premlata. Earlier, she was supposed to speak first, but Dr. Kantikar has a program, has a meeting at 5, and so this morning we had to make a small change in the program. So we have Dr. Kantikar from the NCDRC, who will be talking on medical negligence under the Consumer Protection Act, followed by Dr. Premlata, who will be talking about unfair trade practices under the CPA. So now to introduce Dr. Kantikar, Dr. S.M. Kantikar is a pathologist who did his MD in pathology from Dr. BMGMC, Solapur, Maharashtra. He acquired PhD in National School. Please, if you don't mind, please mute your mics. Please mute your mics, please. Thank you. He acquired PhD in law from the National India University, Bangalore. Please excuse யார் உங்களோட மைண்ட் மியூட் பண்ணிட்டு பேசுங்க. வெள்ளூர் வெள்ளூர் டிசிடிஆர்சி ப்ளீஸ் மியூட் யுவர் மைக். வெள்ளூர் டிசிடிஆர்சி ப்ளீஸ் மியூட் யுவர் மைக். ப்ளீஸ் ப்ளீஸ் மியூட் யுவர் மைக். Thank you. So he started his professional career and was there from 1989 till 2013. In 2006, he joined as a founder teaching faculty of New Shimoga Institute of Sciences under Government of Karnataka. Assistant as a social worker.
Roja ma'am, please excuse us.
Yeah. Yes.
சார் எல்லாருமே ப்ளீஸ் உங்களுடைய போன் உங்களுடைய இதை வந்து மியூட் பண்ணிக்கோங்க சார் ஆடியோவை. we are having a disturbance please.
நீலகிரிஸ் வெல்லூர் ரெண்டுமே வந்து மைக்க மியூட் பண்ணீங்கன்னா நல்லா இருக்கும்.
நீலகிரி மேம் நான் தான் நீலகிரி தான் சொல்லிட்டு இருக்கேன். ப்ளீஸ் எல்லாரும்
சாரி அபவுட் தட். வெல்லூர் தான் வந்து இருந்துச்சு பார்த்தேன். சாரி அபவுட் தட். யா, thank you. Do you want me to start again? Okay.
Yes ma'am.
Yeah, I can quickly do that. So we have Dr. Kantikar with us today, who is honorable member of the National Consumer Disputes Redressal Commission. Dr. S.M. Kantikar is a pathologist who did his MD in pathology from Dr. BMGMC, Solapur, Maharashtra. He acquired PhD in law from the National School of India University, Bangalore. He started his professional career in Shimoga and was there from 1989 till 2013. In 2006, he joined as a founder teaching faculty of New Shimoga Institute of Medical Sciences, Government of Karnataka, and worked as an assistant and associate professor. As a social worker, he started 2 voluntary blood banks, that is Red Cross Sanjeevani in 2006 and Rotary Midtown in 1994 in Shimoga. He was honorary professor in law and medicine in CBR National Law College, Shimoga. He was a member of the District Consumer Commission, Shimoga, for 4 years during 2003-2006. In the field of consumer affairs and law, he completed research projects on impact of the Consumer Protection Act 1986 on medical negligence and right to health, a human right perspective and legal regime for safe blood. He is a resource person for national academic conferences and training programs at various institutes like the National Judicial Academy, Indian Institute for Public Administration, IIT, and IIM Ahmedabad. He was conferred Karnataka Rajyotsava Award in 2021 by the government of Karnataka. We are honored to have you, sir. Over to you, please. Thank you for joining us today. Thank you, sir.
Good afternoon, everyone. Thank you, Saroja from Chennai.
Yes, sir. Good afternoon. Thank you.
Good afternoon. So let us start the subject. I thank you for inviting me for this function also. I thank the State Commission and Dr. Ambedkar Law University and the consumer, the citizens CAG.
Sir, if you could be a little louder, please.
Little louder? Okay.
Yes, sir, please. Yeah. Or if you could move nearer to the mic. Yeah, that would be nice. Thank you, sir. Thank you.
Mic देखो आता है ऑडियो सेटिंग मैक्सिमम नाउ यू आर ऑडिबल यस ठीक है
Now it's very clear. Yeah. Thank you, sir.
ओके ठीक है इधर प्रेजेंटेशन में लगाओ share. I will share my slide presentation.
Yes.
Yes.
Could you please? Yeah. Yes, please. Yes, it is visible, sir.
It is visible?
Yes, yes.
Visible and audible. Okay.
Both
Okay.
are fine. Yes, thank you. Yeah.
Yeah, mic. Good afternoon, participants. I hope the participants are from the district and state commission members and presidents, and even the law graduates from the university and my friends. You are dealing with, I am sure you are well aware with the previous talks about the new Consumer Protection Act, which was enacted, New Consumer Protection Act 2019, which came in force from July 2020. I will not go into the details, but one thing I want to make it clear, there is a misconception or misbelief or whatever, or mistake from the medical fraternity that medical services are excluded from the Consumer Protection Act. And so far, even after 1.5 years, and all the functioning of the fora started, and the commissions started after COVID pandemic, still there is a confusion in district commissions about whether the consumer complaint against medical negligence to be admitted or not. Remember, there is no new act also includes medical services to be dealt. The Consumer Protection Act will deal the medical negligence cases. With this note, let us start. Yes. Yes. Picture. Before. Yes. remember, you must understand the what is the duty of consumer commissions, or the most important thing is the education. Consumer education is necessary. And in the 1986 Acts also, after 3 decades, what I feel, the consumer got the education, and most of the healthcare systems, or most of the healthcare services are there is a consumerism. Now, there is no, as a doctor-patient relationship, you remember the Vaidyo Narayana Hari. It was the saying previously. Now it has gone. Beyond that, now each consumer, each patient know his rights, what I should. And very important, what I said, Vaidya Narayana Hari, it has gone. The changing doctor-patient relationship is the cause of lot of medical negligence litigations are there. Let us understand before, because you all are the members and presidents from the district and state commission. So first we should understand before deciding the case, what are the rights of the patient? Because there are many complaints being filed against the medical professional or the hospital. It is your responsibility as a member or president whether to admit this case or not. You must understand first the rights of the patient. The right is right to be treated with respect. Obtain medical records. Patient has every right to obtain the medical record. Then privacy is his right. Make the treatment of choice. When I will deal with the consent, you will understand what is the treatment of choice. Then the informed consent. There is also he has a right for refusal of the treatment, and he has every right to make decisions to end of his life care support. So these are the, in general, few, I have highlighted few important rights of the patient. So if their right is violated, then the patient or the patient's relative, like a complainant, will file a complaint before different, he will take a legal recourse against the medical professionals under 4 channels. What are the 4 channels? Let us see. Before that, I want to make it clear, the medical services are not excluded under Consumer Protection Act. The Honorable Supreme Court on 29th April 2022 held that doctors and healthcare services are not excluded. Remember. So therefore, don't get confused, because the lawyer, advocate, or the medical fraternity may say that it is excluded. No, it is still pending. Not still, it is included. See, the Honorable Justice E.Y. Chandrachud, he has categorically stated that the definition of service is wide enough under the Act. Service, it is very wide enough if you go through the Act. And if the doctors or medical profession wanted to exclude, they would have said expressly, because this Act, nowhere in this Act, it has expressly mentioned that the services of medical professionals are excluded. Just I told how the complainant or patient exercise his right to the legal remedy. What are the legal remedies for the complainant in the medical negligence cases. So, see, doctor's liability for wrongful act means negligence. It is criminal liability. Then second is civil liability. So under civil liability, criminal liability I will not deal with, because 304A, if you have gone through the Jacob Matthews case, you will understand how the criminal liability will be dealt. Just go through the Jacob Matthews case. Then what is civil liability? So under civil liability, it is a contractual liability and the liability under Consumer Protection Act. And what is PRB? PRB is a professional regulatory bodies. You know, there are different professional regulatory bodies like state medical council in every state. Then the Central Medical Council, it is a Medical Council of India. Now it is replaced by National Medical Council Commission. So then Ayurveda Council, Homeopathy Council, or Dental Council, the different professional regulatory bodies, they have their regulations and rules. The action will be initiated if the complainant files a complaint before the professional regulator. So remember, the patient or the victim or the complainant can exercise his right or liability, seek liability through, one is criminal act, second is civil act. Civil act as a civil liability, it is contract, means four channels: criminal, civil, Consumer Protection Act, and professional regulation. He can file complaint in all places. See, this is my study. The present scenario. What is the scenario of medical negligence cases? I am sure in your commissions also you are getting a lot of cases of medical negligence. Every year, about 5.2 million people die due to human errors. And amongst that, medical negligence is one of the errors. See, this is the study which I took the data collected for the 7 years, 2010 to 2016. And you can see how the drastic change is there. Can you see the pointer? Can you see the pointer?
Yes.
See, in 2010, the National Commission, we have received only 26 complaints. Whereas in 2016, there are 350. Means almost 10 to 15-fold rise in the medical negligence cases. Now, as a member or as a adjudicating persons, if the case before you, any medical negligence case is before you, what you will see? The perception of the medical fraternity or the doctors is that if the complaint is filed against doctor, the consumer courts or commissions are imposing the liability or allowing the complaint. Why this is happening? It should not. If there is no negligence, because you have to analyze whether there is definitely negligence or not. So, what are the ingredients now? How will you assess? One case is before you. One doctor, he has operated the patient and patient died. Suppose this is the case. Now, the onus to prove medical negligence is on the complainant. Doctor need not prove that I am not guilty, but it is the responsibility of the complainant to prove there was a negligence committed by the doctor. So how, unless he prove 4 Ds, all 4 Ds should be there, then and then only the Consumer Commission will fasten the liability on the doctors. So you have more responsibility now. You must analyze the case and you find out whether there are 4 Ds, whether complainant proved all the 4 Ds. What are the 4 Ds? It is the duty towards the patient. 4 Ds of the doctor, it is the duty towards the patient. What it means? Duty towards the patient means, suppose, I will give one example. Suppose one gynecologist is there and one patient will come with the fractured hand and he will come to the hospital. Doctor, you are free. Just do my plastering. Doctor is the gynecologist. Patient came with the fracture. Now, and the doctor will refuse. I don't treat you. Or doctor will do the dressing and she will send somewhere, you go somewhere to the orthopedic surgeon. But unfortunately, further the patient suffer loss of blood, means obstruction and develop gangrene. And his limb, his hand will be amputated. If there is a gangrene, hand will be amputated. Now, whether he can file a complaint against the gynecologist that she did wrongly dressing, because of wrong dressing, I suffered gangrene and my limb was amputated. Now see this case. Now she is a gynecologist. Whether there was her duty to treat such a fracture patient? No, she may refuse. And what she did only dressing and sent. She did not correct the fracture. How she will correct the fracture when there is no duty? Her duty is to see the gynec patients, not to treat the fracture. She has referred properly. So there should be duty towards the patient. The duty should be, there should be deficiency in duty. Suppose doctor is there. I will give same example. The gynecologist is there. The pregnant woman will come at the 37th week of pregnancy, full term pregnancy. And the doctor will say, no, nothing, you don't worry. Your delivery will be normal. You come after 4 days. Without examining the patient, without doing the ultrasound of the patient, she will say, okay, you come after 1 week. There is no need to get admitted. You can only on consultation without examination. Now, patient goes to the house and she started labor pains, and nearby some hospital she will go and the fetus will die. After delivery, fetus may die or the patient may also die. Now, in this case, whether there was a duty of the doctor to see the pregnant woman, yes, there is a duty of the doctor, the gynecologist, to see the patient. Now, whether there was a deficiency, yes, there was a deficiency because she must have examined the patient properly and take the decision whether the patient needs admission for the delivery or whether she needs 1 or 2 days, whether there is need of any induction of labor. So without examining the patient, sending to her house, it is the deficiency in duty that is known as breach in duty. This is the second D. Now third is directly results in the injury. So here was the duty, there is a deficiency, and because of this deficiency, she went to the house and suddenly she got the labor pain and delivered somewhere, maybe in the house or somewhere, and instantly there was a bleeding and she died. So this is directly results in the injury. This is the third is also proved, and the damage. Damage will be definitely proved because damage which may be physical, mental or financial loss. The physical and mental loss the woman suffered because of your wrong treatment, wrong not doing the diagnosis properly. Then what is the mental? She lost the baby or the husband lost the wife also, death of the wife. So there was, so all ingredients, the 4 Ds are proved here. So you can, as a commission member or president, you can fasten the liability on the doctor, the treating doctor. Suppose there is no direct injury. Many times you will get, doctor gave me that injection wrongly and unnecessarily he gave me the injection. Whether this is negligence. Because remember, giving injection is not a negligence. The direct result if the injection is given without test dose. Now I will say, remember one MBBS doctor is there, patient will go to MBBS doctor. There is some injury dressing, he will do infection and he will give penicillin injection. What is the mandate say? What is the standard of practice? He has duty towards the patient. Yes, he will examine, he will clean the wound and dressing. To avoid infection, he gave injection, Penidura, penicillin or any antibiotic. So there is no deficiency also. Then there is no, what law say or what medical science say? Giving any injection, you have to give the test dose, especially penicillin. He has not given the test dose and gave the injection. And there is no reaction, nothing happened. And no damage also. Whether in this case, whether the patient can file a case. What is here? Only deficiency is he has not tested, he has not given the test dose to the patient. But what happened? Not giving the test dose, whether it resulted any injury after giving the injection. No. So there is no negligence in this case. Remember, you have to analyze very meticulously before deciding or before passing liability on the doctor. Whether 4 ingredients are there, whether doctor has that duty. If there is no duty of that doctor, there is no liability. What is negligence? We are talking negligence. What is negligence? But negligence is the act, either omission or act of commission. See the errors, where the errors occur. Diagnosis or evaluation, the medical decision making during the treatment, during the medication, and inadequate supervision, and faulty communication, and procedural complications. See, I have displayed the errors one side and given the example on other side. Diagnosis and evaluation. If the doctor failed to diagnose properly, it is a misdiagnosis. Then the decision making, it is very crucial. If you see the complainant will tell the doctor has not sent the patient within proper time. At the last end, when the patient was sinking, he referred to the other hospital. Therefore, patient died. No. So you have to analyze whether there was an act of omission or commission. What is the act of omission? Before that, I will tell what is the act of omission. The act of omission means what you are supposed to do, what the doctor is supposed to do, he is not doing. That is act of omission. And what is act of commission? What he is not supposed to do, he is doing that. I have given the example of the gynecologist. When the patient comes to the gynecologist with the full-term pregnancy, she should examine and send the patient whatever advice. But she did not. She just watch the patient, okay, nothing to worry, you come after 1 week. This is the act of omission. You have omitted. And what is the act of commission? Act of commission is the similar. What you are not supposed to do, you are doing that. Then the medication, incorrect dosage, incorrect medication is very important. Diabetic patients, wrong dosage, wrong antibiotic dosage. In the cancer patients, the chemotherapy doses are very meticulously calculated and to be given. So just analyze from the medical record. Then inadequate supervision. There are complaints, they will say, the hospital has charged me unnecessarily, the doctor was never visited me during my hospitalization. Then see the case paper, whether he visited, his signature is there or not. If it is not there and unnecessary hospital is billing, his name is in the billing, then definitely it amounts to unfair trade practice from the hospital also. Unnecessarily putting the bills. Some medicines are not given, but the bills are there. So this is the failure, the medication, incorrect dose, and inadequate supervision also. Then the faulty communication, it is very important. The delegation. The doctor will tell nurse, nurse will tell someone, some relative or some fellow, and he will do something. It happened. The doctor advised cancer therapy. The nurse made it ready, but he injected instead of vein, he injected in the spinal cord. Doctor injected in the spinal cord. Then what to do? This is the negligence. Don't delegate. In the faulty communication, then procedural complications like faulty techniques. If it is a Caesar operation or any laparoscopic surgery, if the doctor adopted faulty technique, then you can fasten the liability on the doctor. So what are the different reasons of medical negligence? What you will see, whether the doctor is proficient or not. You are a judge, you are a deciding person before the forum. The doctor, the party is appearing, the complainant will allege that there is no proficiency, doctor is not qualified, he is just a MBBS, but he performs Caesar. You analyze what is his degree, what is his experience, because all the documents, you ask the opposite party to file the document. What is your degree? Let us see, because there are fake degrees also. Some unknown degrees are also there. We have seen they mentioned ABC also as a degree. We have received some revision petitions. The doctor has mentioned, they mentioned very hyper technical terms, the bone setter and the something like this. So one prescription we saw, I'm an AIDS specialist. AIDS will be cured 100%. So this is not, such persons should be punished, remember. Then the second is procedures. I mentioned in the last slide procedural difficulties or procedural mistakes. Suppose if he is doing FNSC, FNSC means the needle will be inserted in the tumor and they diagnose it. While inserting the new tumor in the abdomen, there may be puncture of the kidney or the spleen also, which results into torrential bleeding in the abdomen and patient will die instantaneously. So procedures, lumbar puncture, any procedure, take any procedure, there will be negligence. You have to analyze. Then the decision making, just we saw, and communication also. See both the lines, see very carefully. Both the lines are confusing. Contract of service and contract for service. Now you determine negligence against the opposite party. Now the question is, who is liable? Whether the doctor is liable, whether the hospital is liable, or others are liable. See, the contract of service means a vicarious liability. If the doctor is working in that hospital, or doctor is employed, or he is a consultant in that hospital, in that case, it is known as vicarious liability. The wrong done by the doctor, he will be also liable. Along with that, the hospital where the treatment taken place, that hospital is vicariously liable. Then second line, it is a contract for service. It is the doctor, individual doctor is responsible because it is a contract for service. It is the relation is established, contractor and client contract. It is an independent contract. Their employee and employer contract is there. So remember both the terminology. If you want to fasten the liability, analyze who is negligent. If the hospital, because hospital has liability, vicarious liability, because hospital is earning on the doctors also. There's crucial points where the doctors fail. You have to pluck out as a member of commission. You have to pluck out these pitfalls. The medical record. The medical record is a vital document, and most of the doctors are confused by the medical record, what it is, why it is, how to prepare, how to maintain, and how to destroy. Remember, the medical record is a property of patient or the complainant because he has paid. Hospital has the complainant has every right to get the records from the hospital in writing. Within 72 hours, hospital shall issue the record. If the records are not issued within 72 hours, the complainant or the patient can approach Medical Council of India, now it is NMC, or the State Medical Council to take action under 1.3 regulation as a professional misconduct. Now we'll move to the informed consent. Just this is a medical record, a major confusion, same, just I told within 72 hours. So just when you deal with the case of medical negligence, meticulously see the referral note if patient is referred outside, whether patient was referred in time or delayed reference. Then the discharge note is very important. Just observe the discharge note. Should be all details. Many times the hospital will mention a discharge before and admission letter on the date. So just see the and discharge note should contain all the details of the patient treatment. Then when dealing with the confidential record, medical record, this is very important. If the doctor declare the confidential, open the confidential information, then he is definitely liable for negligence. If there are corrections, many times the medical record are corrected, and you will understand the ink is changed, there is an interpolation, there is scratching or scrubbing and other things. Just and if you find, you ask for the OP, opposite party, what is this, and let them explain. Then there are tampering, also correction, tampering same, and destruction is not our area. Remember, as per NMC or Medical Council of India, any doctor has to preserve the medical record for 3 years. Beyond 3 years, he can destroy the records with the giving intimation. So this is the best defense for the doctor if the case is filed after 3 years. What you will see in the record, good medical record is, it should be in the client's word, there should be clarity, it should be complete, there should be conciseness, it should not be vague enough. Then it should be in the chronological order. What I said, the date of discharge will be 1st January and date of admission will be the 10th January. So this you can very meticulously read the document. So what we expect, what we as a members of the commission, adjudicating commission, we expect the medical record should be neat, legible, it should be timely provided and accurate with the professional tone. And the confidentiality, yes, it is another. Now, it is very important. Remember what in the most of the medical negligence cases, there is allegation of consent, there is allegation of wrong dosage, there is allegation of misdiagnosis. These are the 3 areas. If you analyze, you will write a judgment on medical negligence very easily. So remember the consent. And third is consent. Very important is consent. What is consent? Consent is not a mere signature on the dotted line. Remember, if you come across such a consent, then definitely you ask the opposite party or complainant, why you have signed the consent like this? All the gaps are there. Printed form, all the gaps, no name, nothing, and just signature of the patient or the relative. How will you understand whose consent it is? Now they have started mentioning the consent everywhere. So remember, consent is not a signature on the dotted lines. Consent is not mere acceptance of the medical intervention, but voluntary informed decision by the patient whether or not to opt for particular medical procedure. Remember, there are certain instances consent is implied. Suppose the patient goes to the doctor's clinic, there is a mutual consent. Yes, patient accepts the doctor and the doctor accepts the patient to examine him or her. So it is an implied consent. But for any invasive methods, for any invasive means any bodily touch and piercing the body, that you need explicitly the consent, informed consent. See what doctors say. Doctors often take the general consent. If you see your files tomorrow, just take one file and just go through the consent. Most of the doctors often they take consent as a general consent. That is wrong. Don't accept such a consent. The actual risks discussed are not documented on the consent form. The doctor's evidence will say, I have discussed with the patient and his relative about the complications, but that is not recorded in the our consent form. Then there are certain things, the allegation of the patient, doctor said me it is very small procedure, there is no this thing, this is the thing. So analyze the consent. There is no such a thing that minor operation or major operation. Consent is consent. It is necessary for all the operations. Then consent should be procedure specific. It should not be just printed and I understood all the things and this and both have signed. Then what is the informed consent? Informed consent is, remember, brand, the word brand. The consent should explain benefits of treatment, risk of treatment, alternatives of treatment, no treatment, and documentation plus signature. 4 baje tak hai? It is up to 4. Okay. So there are few cases how the consent evaluated. I will try to circulate this slide to the organizer. You all participants will get this slide after my talk. The important cases of consent, how the consent evolved. You all are coming across the Bolam's test, and Bolam's test is the landmark, and Indian courts following the Bolam's test for the standard of reasonable practice. It is a standard of care and standard of reasonable practice. After that, evolution, Canterbury, Sidaway, and our Indian Samira Kohli's case. You also take down the Samira Kohli's case, download and read the Samira Kohli's case. It has laid 11 principles what constitute the informed consent. And very recently, Montgomery versus Lanarkshire, it is very landmark judgment in the United Kingdom, in London, England. It has elaborately discussed, and now the concept of Bolam's test is receding. Many times you will come across the doctor referred the patient because he is not competent. No, referring the patient is not a negligence. Many times this happens. The district forum will award he has referred unnecessarily. No, referring the patient is not a negligence. See the chart here. This is good medical record is good defense, poor medical record, poor defense, and no medical record. So there is no question you can fasten the liability directly. See this slide. What do you see? What is res ipsa loquitur? Many times we use this terminology, res ipsa loquitur. In the Nikhil super specialty case also it has discussed. And in the recent judgment of Honorable Supreme Court, in that Asha Goel's was judgment versus Bombay Hospital versus Asha Goel, it has discussed this res ipsa loquitur. What is res ipsa loquitur? The things speak on itself, the facts of things. There is no need to prove the complainant. If the operation of the right hand to be performed, wrongly it is performed on the left hand. I think you all remember the famous actor Sridevi's mother. She was operated in USA on the wrong side of the brain. Instead of right brain, they have operated on the left brain. This is a negligence. There is no need to prove. See this figure. Actually, you are watching the seizure is in the abdomen, in the pelvic cavity. It has missed. So what you need? What doctor will prove? There is straightforward and the liability, it is a res ipsa locator. So I have made the compilation of important judgments. I will circulate this slide, and if you click, read the full judgment, you will get the entire judgment. I have collected the judgments of Honorable Supreme Court and of the National Commission also. So this is the thing. So thank you very much for the patience, and I will be happy to answer your queries, if any.
Thank you, sir. Yeah.
Is there
Any
any question?
questions? Please raise your hands.
Thank you very much.
One clarification, sir. Section 2, subclass 42.
Yes.
Section 2, subclass 42, sir.
No, I could not get you. What you want?
Section 2, subclass 42 of CP Act 2019, sir.
Yes.
Section says that last line, sir, does not include the rendering of any service free of charges or under a contract of personal service. In this
Yes, it
service,
is. Yes, what you want to ask?
free service means that government hospitals comes under this medical negligence, sir.
Yes. So remember
Interpret, sir.
the free service. What is free service? If you go through the IB versus VP Shanta's case, Honorable Supreme Court in paragraph 55 and 56 clearly explained what is free service. Now I will say you what is free service. If the hospital, charitable hospital or government hospital is giving free service to all the patients, whether he is rich or poor, then that hospital is exonerated under Consumer Protection Act, free service. Now suppose the hospital, if it is a charitable hospital, a big charitable hospital, there are beds. 25 beds are free beds. If the patient treated under free beds, your question is if the patient is treated under free beds category, whether he can file the complaint. Yes, he can file the complaint against the charitable hospital because only 20%, 20 or some 10% beds are charged free, but other patients are charged whatever the charges are. So the charges of this treatment, free patients treatments are recovered for the patients, the charges of other patients. So it is not totally free service. So such hospitals attract Consumer Protection Act.
Any louder, sir, please?
Yes. Next.
Any other questions?
Yes. Not audible. Yes, correct.
Yeah, not able to hear you, please.
Hospitals. Yes. Can you repeat the citation, sir? The page number 54 to 56.
Can you hear us? Is there something pertaining to the same?
Ma'am, voice
Hospital.
ma'am.
Sir, you're not audible, sir.
Hello. Yes.
Sir, can you repeat the citation, sir? Just now,
Huh?
Can you repeat the citation, sir?
No, I will circulate the presentation with you. Don't worry.
Sir, whether the VP Santa's case still holds good or there is any change in that?
No, VP Shanta's, still we are following VP Shanta's case for the free services. It has elaborately discussed the categories of the hospitals which come under free services, which are not under free services.
Yes, but recently Supreme Court has given some in a Saprathem's case, recent judgment.
Which one?
Saprathem's case, Delhi case.
Which one? Safdarjung case.
Yes, yes.
No, it is still
There's a slight light of confusion in there. In case if the hospital charges assuming that they are charging for an X-ray, taking X-ray.
all the government
Other things are free.
all the government hospitals are not charging. They are charging for
Whether
the
the hospital
registration.
can be the government hospital.
The government hospital
Government
which are
hospital.
yes. Even the All India Institute of Medical Sciences, All India Institute of Medical Sciences is liable. There are judgments of National Commission and Supreme Court also. See, the government hospital, if it is totally free, if there are private rooms and they are collecting money from the private rooms, then in that case, the government hospital is liable for the negligence for all the patients.
Sir, your voice is breaking, sir. We are not able to hear you.
Sir, you have stated that the medical records are the properties of the concerned patient, but whether it is applicable when the patient is treated as OP.
Madam, you just pass on the question to me.
Yes, sir.
I am unable to.
Yes. Actually, your voice is very feeble. Could you please be a little louder or please speak close to the mic?
My voice, huh?
No, not yours, sir. Whoever was asking the question, yours is clear. But I'm just someone was asking the question, but it was not clear.
Let me repeat the question. Sir, now you have stated that the medical records are the properties of the patient. Medical records are the properties of the patient. Whether this will be applicable even for the patient who treated as OP, outpatient. Madam, can you pass on the...
Sir, can you explain once again 4D interpretation, sir?
Which one?
4D.
No, you read the section. You read the section, I will explain. What is it?
Please read the section. He's asking you to read the section so that we can explain.
Hello? Yes, madam?
Your presentation 4D, sir. 4D.
4D, madam, just read the 4D because Act is not in front of me. I can't remember all the sections. I have to refer.
Duty towards patient, deficiency in duty.
4D निकलो अपना Act निकलो किधर?
Essential of negligence are 4Ds.
You read the section. उधर नहीं है book.
Excuse me, sir, this is regarding with respect of your notes. The question is regarding with respect of your notes for these. That is essential.
In
Towards
my presentation, you are referring my presentation. Okay.
Yes.
Okay. Just we'll go to 4D. Again, I will explain you what is 4D. I thought section 4D you are asking. Okay, this is 4D. I will explain you. The patient or complainant has to, if he want to succeed in his claim, he has to prove all the 4Ds against the doctor. First thing, he has to prove there was a duty of the doctor toward this patient. What I told, if the patient is, suppose patient is admitted in the hospital, patient is admitted in the hospital under some doctor's unit. One doctor, physician will admit, and the patient start abdominal pain, sudden abdominal pain. Now physician has the duty, he will examine and he will send the call to the surgeon. He has no duty to perform immediately operation. Then the second D is deficiency in the duty. What is the duty? Doctor has the duty. I gave the example of penicillin injection. Any penicillin injection, you have to give the test dose. This is the duty. But doctor fails. Sometimes he will not give the test dose and give the injection. Immediately patient will develop drug reaction. In this case, if there is a drug reaction, that case, he has not given the test dose, that is known as deficiency in duty. Okay. Suppose there is no reaction at all. The penicillin injection is given to the patient without test dose. So there is no liability. Though there is a deficiency in duty, but that deficiency has not resulted directly to the injury. Patient is very comfortable. There is no reaction, nothing. So the complainant cannot allege. His allegation may be there. Doctor has not given me this test dose and given me penicillin injection. But what happened? There is no reaction, nothing. So there is no direct result. That deficiency, that breach should result into the injury. And after injury, the damage, he will suffer mental, the family members will suffer. So this is the 4D. What do you need? Anything more?
Sir, earlier you have stated that medical records are the properties of the concerned patient. Whether, my question is whether it will be applicable to the patient who treated as a outpatient, not as inpatient.
Yes, any prescription, any medical record in the hospital record, it is the property of patient. And every hospital is keeping their record with them. Now it is the responsibility of the hospital to preserve the record. And whenever the patient or complainant asks, I want my medical record, it is their duty to give the record within 72 hours. If he won't give, then he can take the action against the doctor or airing hospital under professional misconduct. Now you are asking OPD records. OPD records, most of the doctors, they hand over the prescription slip to the doctor, patient. So it is with the patient. Now the patient has to prove. If he is alleging, I went to that doctor and he gave me this prescription and he lost the prescription. Suppose he lost the prescription. Now you are dealing with the complaint. He will say, I went to that doctor, he has not examined my so-and-so and gave this medicine. You need that document to fasten the liability. If this is the responsibility of the patient, he has to preserve and he has to produce before the court. How will you proceed further if there is no document?
So I have a doubt, sir. Is a free medical service provided by the ESA Corporation is a service under the Act or not?
What?
Free medical service provided by the ESA Corporation is a service or not under CPI?
ESI Corporation providing service, the negligence in the ESI's hospital shall be adjudicated in the consumer protection, because there are few judgments that the person who is serving there, some quantum is deducted towards the contribution to the ESI or the medical health services of his family. So this contribution is taken as a consideration. So that service is not free service. Already he has paid. Yes. Yes.
Sir,
I see one hand raised, CVSCDRC. So do you have a question, sir?
yes, I have the question. The free medical camp, some of the doctor associations of the NGO, will come under the purview of Consumer Protection Office.
Can you please be a little louder?
So his question is free medical camps, whether it comes under the Consumer Protection Act.
Yes, sir. Yes.
It will not come under Consumer Protection Act. There is, I'm not remembering the case. The ophthalmology camp was held in somewhere, and nearly 10 to 15 patients lost their vision. Honorable Supreme Court laid down certain guidelines before holding the camp. The organizer should do 1, 2, 3. These are all the mandatory requirements. This is the thing. And it is a free service, but if they won't do the proper assessment, that time civil liability or criminal liability will take place on the organizers. Why they have not provided the infrastructure and other. But he cannot come to the consumer court.
Okay, sir. Only for criminal liability. Yes, thank you, sir.
Are there any other questions, sir?
Yes, some Nanda Gopalan.
Yes, sir. Sir,
Yes.
very
Yes.
good afternoon. This is Nandagopal from Chennai
Yes.
South, sir, member 2.
Okay.
Sir, is there any provision to cross-examine the doctor during any course of medical negligence case, sir?
No, the act, you go through the J.J. Merchant case and some other cases. Ours is a summary proceeding. Cross-examination, calling the doctor, it will entail the time for the doctors also and the court time also. Best way, there is no provision as such. You can, if there is a question of, if you want to understand or anything, you can call the doctor for the cross-examination.
Okay.
But don't keep him for waiting more, because cross-examination, then affidavit, it will entail time. Better, if you want to cross-examine, ask the complainant or ask the parties to file the interrogatories, use the time to reply the interrogatories and proceed the matter for the arguments. That will be best, because the repeated adjournments and repeated, because doctor will come from different place.
Yes.
And that time unnecessary, because he, whether he has posted few operations, he has to postpone, and if he is in the emergency, if he will not come, then what you will decide? Best way, or take the cross-examination online, video conferencing. It is now in this new provision is there. Certainly, if you want, doctor has the computer, you can log on and take the cross-examination.
Yes. Yes, sir. Thank you.
Not doctor, any, suppose any party, doctor
Yes.
and complainant also. Yes.
Yes, sir. Thank you.
Okay. So any question, madam? Thank you, Dr. Madam Saroja, and all the participants.
There is one question,
Yes.
District Commissioner Nagarkoil has raised their hand.
Hello, sir. How are you?
Fine, fine. Okay.
So thank you so much, sir. On behalf of our presidents and the Tamil Nadu members, we are wholeheartedly thanking you for sparing your valuable time, and your presentation was very much impressive, very informative too, sir. Thank you so much. Very kind of you, sir.
Thank you. Thank you.
Really, very thank you so much, sir.
No, see, madam, I am sending you my presentation in PDF format,
Yes, sir.
and you circulate all the members who are present here.
Yes, sure, sir.
Either WhatsApp or through email, you can circulate.
Yes,
I'm
sir.
sending in the WhatsApp. Okay.
Yes, sure,
So,
sir.
entire presentation in the immediately within 5 minutes you will get it. Okay.
Okay, sir. Thank you. Very kind of you. Thank you very much, sir. Thank you for joining us today amidst your busy schedule. Thank you very much.
So, thank you. I hope I have made something clear about the medical English because it is very vast subject. I need a whole day to convince and to teach the people. Huh? So thank you. Thank you.
Thank you. Yeah.
Thank you.
Thank you very much, sir. Thank you.
Thanks. Okay.
So I think we should probably be taking a 10-minute break so that the next speaker joins us because it's 3:35 now. So we will probably take a break and we will reassemble at 3:50. Is that okay? Yeah. Thank you. By 3:50, let us reassemble and we'll hear to the next speaker. Thank you very much.
அது கரெக்ட் பண்ணுங்களா?
நம்பர் பில்லு
நான் நாளைக்கு தான் கொண்டுறோம். வீட்டுல கரெக்ஷன் பண்ணீங்களா? எங்க போயிடு? சைன் போட்டேன். ஆயிட்டா மீட்டிங்கு? முடிஞ்சுச்சா? ஆ
லாவண்யா மேடம், நீங்க உங்க ஆடியோவை வந்து மியூட்ல வைக்காம பேசிட்டு இருக்கீங்க.
அது வரல. அதுதான் நான் கேட்டேன்.
ஆமா, உங்களுக்கு எந்த சிம்பலுமே வரல.
இப்போ வருது மேம், இப்போ வருது. ஆடியோவே வரல மேடம்.
நீங்க வெளிய போயிட்டு ரீஜாயின் பண்ணுங்க. எல்லா ப்ரொவிஷனையும் எனேபிள் பண்ணிட்டு.
ஓகே மேடம்.
So let us start for the next session on unfair trade practices under the Consumer Protection Act. We have Dr. Prem Lata with us. Dr. Prem Lata was a member of the Consumer Commission during 2001-2013. She was an advisor member to Script Committee of the Ministry of Consumer Affairs, Government of India, for creation of consumer ads and serials on landmark judgments to create awareness. She was the legal expert at the National Consumer Helpline managed by the Ministry of Consumer Affairs during 2014-2017. She was a member of the committee appointed by the Ministry of Consumer Affairs for drafting rules and regulations under the Consumer Protection Act 2019. Dr. Prem Lata is a registered arbitrator at Center for International Arbitration, High Court, and Indian Council of Arbitration, Government of India. She is a mediator at District Court, Dwarka, New Delhi since 2015 and has been recently appointed as mediator at the NCDRC. Some of her work that were published include Existing Legal System in India 1993, Understanding Mediation 2010, Medical Negligence under the Consumer Protection Act 2019, Mediation of Consumer Cases, Consumer Protection Act 2019, Consumer Protection Act 2019, New Dimensions. The last three of her publications are available on Amazon. We are happy to welcome you, ma'am. Over to you, please.
Thank you, ma'am. Thank you very much. Can you all hear me? Can you hear me?
Yes,
okay.
yes. Thank
okay.
you.
Yes,
Thank you very much, ma'am. Saroja, ma'am, and CAG. I thank a lot to you for giving me an opportunity to interact with the legal luminaries available on your web now. Thanks a lot. And I'm glad to interact with you people. Though I don't have my list with me, as Madam Saroja said, that it is your Tamil Nadu all state from Consumer Forum Commissions and state commission members. So welcome all of you, and I'm glad to meet you. Today's subject, let us start without wasting time, because we have got the time and we have to finish all the things within that. I would like you to see you all of you. Can you please hello? Can you please put on your cameras? At least I can see once to you, all of you. Okay, what is happening? Okay. So our subject today is unfair trade practices. So since I am talking to a legal class and judges of the country, so I will say one thing: unfair trade practices for other persons, for consumers, and for layman is definition, what we have said in the act. But for you people, it is unfair means whatever is not fair. And it is the discretion of the judges to decide what is not fair. And the whole judicial system lies on this thing. What is not fair is injustice, and what is justice is to be done with your fairness. What you feel is okay, it is the discretion of all of you to decide what is unfair. But however, I have already made PPTs, and unfair trade practices definition also we will definitely discuss. This is for the layman to come before you. This is unfair. So we'll go accordingly with the PPTs also. Next, shall I start, or shall I start from mine, or you will do it? I too have this thing.
Is the
Shall I
screen
start
visible
like
to
this?
you?
Huh?
Yeah, actually,
Ma'am, your voice is not properly audible,
Clear?
ma'am.
Not audible. Is it
Yeah, ma'am.
okay? Okay.
It's very
Yeah,
low voice, ma'am.
It's
No
actually
voice.
fine.
No voice, you say?
Yes,
Ma'am,
ma'am.
your voice is audible, ma'am. I think we have to, others will have to check their bandwidth.
Clear. Absolutely clear.
Is it clear?
Yes, yes,
Clear.
yes. It's clear.
It is clear.
Yeah.
Shall I go ahead?
It's okay.
Yes, ma'am.
Please.
Yes, ma'am.
Shall I go
Yes,
ahead?
proceed.
Yes,
Proceed.
yes,
Proceed.
Yes, ma'am.
Okay. 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 Now I'm coming to the first this thing, background of unfair trade practices. How this word came to Consumer Protection Act. Unfair trade practices was basically a part of MRTP Commission. Unfair trade practices and restricted trade practices inserted by Amendment 1993 and applicable on 18/6/1993 under Section 2, subclause F. So this was the initially first time when it came to our act. Further scope was enhanced in 2002 and added new words elaborating the terms unfair trade practices as it is now in our act. Then MRTP Act was repealed and replaced by Competition Commission, as you all know, 2002. Consumer Protection Act 2019 mentions specific word unfair trade practice as a clause for consumer along with goods and services. See, earlier what was there? Earlier only we were talking about goods in 1986. Then in 1993, services also came into the act. But now in 2019, this specific clause has been inserted. Unfair trade practices is also one of the causes for goods, for services, and for unfair trade practices. You can come to the consumer courts for your redressal of your grievance. This is the new thing has happened. This thing in our this thing. Next, what are the new dimensions given to unfair trade practices? Very important clause, unfair contract, has been inserted in the act. Section 2 of 46 defines unfair contract. Unfair contract means whatever contract is not, court does not see it as a fair contract. Some clauses, court can struck down the clauses which are unfair. Now, what are unfair? Unfair means a contract between a manufacturer or trader or service provider on one hand and a consumer on other, having such terms which cause significant change in the rights of consumers, including the following names. Consumer rights are hampered if by some clause, then court can struck down that clause. Requiring, what are the clauses? Requiring manifestly excessive security deposit. Supposing in the terms excessive security deposit has been asked and both the parties have not having any equal bargaining power and consumer ultimately has to sign it. That is unfair clause. Falsely represent that the service are the particular standard quality or grade. It is not, but they have told lie. So in that case also, it can be struck down. It is coming unfair. Imposing any penalty on consumer or breach of contract thereof, which is wholly disappropriate. Whatever is disappropriate, it seems to the court it is disappropriate. It is not in the tune to the welfare of the consumer. Then court can struck down that clause. Next is refusing to accept early payment or debt on payment of applicable penalty. There are some clauses in some agreement that you cannot repay before the term is over. That also is considered as unfair clause. Entitling a party to contract to terminate such contract unilaterally without reasonable cause. Both the parties are there to sign, but there is one clause that's unreasonable. For unreasonable reason, one can struck down the terminate the contract. That is also unfair. Permitting or has an effect of permitting one party to assign the contract to detriment of the other party. Whatever understand imposing on the consumer any unreasonable charge, obligation, or condition which puts such consumer to disadvantage. Meaning thereby, in totality, you can say whatever clauses are not in favor of consumer and they are actually depriving consumers of their rights, which are actually set in the act that these are the rights of consumers. So in such circumstances, this is the first time first time that unfair clause can be struck down by the court. It is the discretion of the court to decide whether it is unfair or not. These are the parameters. These are the you can say parameters on the basis of which court can decide. Again, I say it is the discretion of you all. Consumer can come with these parameters and say it is unfair clause. Consumer can come that say it is unfair trade practices because it is written in the act. But it is the discretion of the court to decide whether it is really unfair trade practice or it is really unfair clause. That is up to the court. Now we are coming to next, unfair practice. What is unfair practice? It is defined under section 247. Again, I say it is unfair trade practice means which is not fair. What is not fair? Making any statement, whether orally or in writing or by visible representation, including means of electronic records, falsely represent that goods are of particular standard, quality, quantity, grade, composition, style, or model. Consumer can come to you with these things that this is false representation. Falsely represent that service is of particular standard, quality, grade. Sorry. Can you share with this thing with me something going on wrong? Can anybody share?
Yes, ma'am. It's very
Hello?
clear.
Yes, ma'am.
It's clear?
Yes,
Clear,
yes.
ma'am.
Clear, ma'am.
Okay, okay.
Yes, madam,
Okay.
very clear.
Very clear. Okay. Now, unfair trade practices, we are coming next. If I have to go next, okay, this way I'll go. Falsely represent that the services are particular standard, quality, or grade. Then, falsely represent any rebuilt, second-hand, renovated, reconditioned, or old goods as new goods. This is all about representation. How a person represent about the product. Represent that goods or services have sponsorship, approval, performance, characteristics, accessories, use, and benefit with such goods and services do not have. Whatever they are representing and they are not, that is unfair in the eyes of, before the eyes of law. Okay. Now represent that the seller or the supplier has a sponsorship or approval affiliation with such a seller or supplier does not have. I'll come to the real cases on these all issues. First, let me discuss the definition, although it is not very important for you people because you have got act with you and you know it thoroughly. But since I have to explain, once let us go ahead, then we'll explain case law and other things. Makes a false or misleading representation concerning the need for or usefulness of any goods, gives to a public any guarantee of the performance, efficacy, or length of life of the product or any goods that is not based on the adequate or proper test thereof. These are all false statements when somebody gives. Trader, manufacturer, or dealer gives all these false representations that amounts to unfair trade practices. Okay. Now I'm coming to you with the case law. Case law, how it led to unfair trade practices coming to the act, and what is the background of constitution of CCPA? Why am I talking about CCPA? Now there is a Central Consumer Protection Authority established under the law, which deals with unfair trade practices and misleading ads only exclusively, not exclusively, with the rights of the consumers also. Whatever rights we can discuss, there are 6 rights also given to the consumers that you all know. I am not going to explain much about the definitions, but we have to discuss and interact and exchange our views. That is what I find this group is meant for that. So development of concept of unfair and misleading ads through landmark judgments. What are the judgments and what was discussed in those judgments and how unfair trade practices become so important to be included in the Act, and particularly why Central Consumer Protection Authority is constituted and what Central Consumer Protection Authority will do under unfair trade practices. It is very important. It has become important when we talk about unfair trade practices. We cannot leave Central Consumer Protection Act, its activities and how it will work. Buddhist Mission Dental College Hospital versus Bhupesh Khurana and others. 13th February 2009, Supreme Court had decided this case. Earlier, this case was taken up by National Commission. National Commission has also held institute responsible and deficient in services. What was discussed in this case? There were 11 students, those who participated, those who took admission in this institute, and finally when the whole course was over, they came to know that it is neither affiliated nor recognized as it was said. It was not recognized by Bodh Gaya University, nor it was affiliated with Medical Council of India. So they filed a case. National Commission held that they are deficient in services. In this process, it was discussed at large before the Supreme Court also, because the other party contested that we have not done any deficiency in services. Whatever fee was paid to us, we have given them education, and all have taken throughout the year. They have taken their admission and they have taken the services. So how we are deficient? So what came to this thing? They gave misleading ad, and due to this misleading ad, students had entered into their institute and they studied the whole year. They wasted their whole year, and at the end, when they went for jobs and all that, they came to know that neither the institute is affiliated nor it is recognized. So Supreme Court said it was misleading ad amounts to unfair trade practices. This was particularly discussed in this case at length, although State Commission in 2004, when it decided the case, they said deficiency in services, but at length it was discussed that misleading ads means unfair trade practices. Thereafter, misleading ads become very prominent feature for consumer courts to discuss in various cases. Hence, giving misleading ads were considered unfair trade practices. This was the stage when it happened. Now, next was development of concept. Then was development of concept of unfair misleading ads through landmark judgment. Orders by the consumer commissions against misleading advertisement remained unimplemented, and such ads continued in spite of orders not to publish in future. See what happened. I was also there on board. At the time, many orders were made that this is misleading advertisement. It should be stopped. There were three type of orders. Number one, consumer should be compensated appropriately. Cost of litigation should be given to the consumer. And third was always that this ad should be discontinued, or it should be amended, or it should be stopped, whatever order was there. What happens in consumer court, after 1 month, if for 1 month consumer has to wait, and after 1 month, if the other party doesn't implement the order, consumer has the power to come. He is facilitated, and he has a power to come. He has the right to come to the consumer court, wherever from where the order was given, come and file an execution petition. Consumer comes and files execution petition. Execution petition is taken up, and immediately, before coming to execution, those traders and manufacturers used to give compensation, everything to the consumer, so that consumer doesn't come to the court for execution, and that ads continues. And court doesn't have the suo motu power. Consumer commission do not have the suo motu power to go ahead if it is published continuously. So was required that there should be some regulatory authority, there should be some system, and there should be some body who can check this. Because if no execution petition is filed, then court cannot do anything and consumer court cannot catch those ads which are already ordered not to publish, but they go on publishing. So this is how it happened. Hence, some such system was required to catch the offender. What I am saying, why CCP was required. CCP is meant to stop unfair trade practices. Now I come to a case, very important case you all must be knowing. In 2019, there was Amrapali Sapphire Developer versus Amrapali Sapphire Flat Buyers Welfare Association, and it was ordered on 6th August 2018. It went up to Supreme Court. 43 home buyers had filed the case before the National Commission, and National Commission accepted and dealt with this case. Now, the plea by the builder was that all 43 consumer, how could they come to National Commission directly? First of all, 43 consumer join together and come together? That was the first question. Secondly, if 43 buyers have come together, calculated their amount, and it comes to more than crore at that time, in 86 Act it was, becomes more than 1 crore, and they came to National Commission, skipping District Forum and State Commission. So this was the objection taken by the builders, which was dealt by National Commission. Yes, they can file together. There was a clause in 1986 Act also that more than one consumers can join together and file their complaint. Okay, that was fine. Taken that provision into consideration. So National Commission said, yes, all consumers could come together. Now the question was, can they skip lower courts, district forum and state commission and come to National Commission straight away? That was also held. Yes, they could do. What was actually discussed? It was class action. Class action against any unfair dealing by the traders, by the manufacturer, by the real estate matter also, by the builder also. So class action theory evolved by this act, case only, and Supreme Court also finally said, yes, it is a class action. Many consumers can come together. One can be leading case, and for the sameness of interest, they can come together and file the case, and they can also skip lower courts if amount collectively becomes more than the jurisdiction of that particular commission. So what is class action theory evolved? Paramount feature of unfair trade practices, now CCPA subject. Now it is CCPA subject. It has become now necessary. How background of the constitution of CCPA, I'm explaining. Misleading ads and unfair trade practices no more a separate issue. It has become an issue which can be dealt by a regulatory authority called Central Consumer Protection Act, and this is the body which looks after unfair trade practices. Anybody can. Now I'm coming next to how it functions and how it will be dealt with. Amrapali case is done. Now is 43 where this is done. Now, again, I'm coming to next issue. After sales services were refused by the manufacturer, dealers, and service provider, stating what they were stating: products sold not with our consent. There was a case before Supreme Court in the case of Amazon versus Sony India case. What happened? Amazon had sold Sony TV, and it was not giving after sale services, no warranty and no parts, nothing. So when the consumer came before the court, what Sony said, Sony had an argument: we have never authorized Amazon to sell our product. From where it has picked up, who was the dealer, whether that dealer was authorized dealer or not, we do not know. From which store they have picked up and sold to the consumer, we do not know. So we will not provide after sales services. This was the argument given by Sony TV. Then next was product not sold by us, third party platform. Intermediary are not responsible. They on Amazon, Flipkart, all these, they say, we are middleman. We are just giving them platform. We are third party. We are not responsible for what has been sold by the dealer and all that. They also just taken no responsibility of the product. Then warranty terms not followed by consumer. This was also one plea taken. Whenever somebody comes with a warranty card, that this is during the warranty period, now give us after sales service, they say our terms you have not followed. Now we are talking about unfair contract also, unfair contract terms also. We have reached to this stage because of these behaviors of the seller, dealer and manufacturer. Unfair clauses in home buyers agreement. Supreme Court's number of judgments have come up now saying if there are any unfair clauses signed by home buyer and the consumer, court can struck down those clauses that Pioneer case, you all must be aware of those cases. So acts considered unfair, hence product liability and express warranty clause inserted. Let me tell you what is the product liability clause here only, because we have to go by the time. It's okay, but I have made this. Product liability. This is product liability clause. Section 234. Product liability means the responsibility of a product manufacturer or product seller of any product or service to compensate for any harm caused to the consumer by such defective product manufactured or sold by the deficiency by the dealer is deficiency in services related thereto. Meaning thereby, if product is sold, let me go back to that only. Responsibility of the product manufacturer or product seller or any product, services, whatever product is sold by manufacturer, dealer or any manufacturer's dealer or any seller. Whosoever sells it, he is responsible if some harm is caused to the consumer by such a defective product, then meaning thereby, if the product is found harmful, hazardous, that is to be compensated by those manufacturer, dealer and other. Before that, this clause was not there because as I explained, that product liability of the product was not taken by Sony, Amazon or anybody. They said it's not my liability. Everybody said it's not my liability. So this product liability clause has been inserted purposely in the new act, and to comply with and to implement it is the responsibility of court as well as CCPA. CCPA is a regulatory body who can suo motu take cognizance of such events, or any state informs, center informs, or anybody informs, or any organization informs that this thing is happening in the market, they are to take suo motu or by any complaint and take up the matter. Product liability clause is this. Now, next is product liability clause. Product manufacturer. Who is considered product manufacturer? If you say this is seller, this is dealer, and who is the manufacturer? So it has been defined very clearly in the act. What is the manufacturer? It's not only the person who manufactures. See, understand section 2 of 36 where it has been defined product liability, product manufacturer who makes any product or part thereof, product makes it, product manufactures it, assembles parts thereof made by others. Somebody else has manufactured, but he has assembled. The person who assembles is also responsible for product liability. Puts or causes to be put his own mark. If he puts his own mark on the product, then also he is responsible. He is considered as manufacturer. He will be responsible and he will take responsibility if some harm is caused to the consumer or product is faulty or any warranty period, they have to make good of that loss. makes the product and sells, distributes, leases, installs, prepares, packages, labels, markets, repairs, maintain such product or is otherwise involved in placing such product for commercial purpose. Whosoever is indulged in commercial activity and does all these acts is manufacturer, meaning thereby if a product has come to the market and it is sold, all of these persons are responsible to make good of that. Nobody can escape now. Product liability clause, and now I'll come express warranty also. That is also one clause added to the act. It is express warranty. What is express warranty? Express warranty means once the product has come to the market, it is sold to the consumers, it carries express warranty. Warranty is there definitely and necessarily. Whatever product is harming or defective, consumer can come to the consumer court for responsibility of all those I have explained. Manufacturer, whether manufacturer, dealer, the person who assembles, the person who packages, all these things who does, it is liability of all those to make good of loss of the consumer who has suffered or who has suffered harm or who has suffered by monetary loss, whatever. So this is actually express warranty. Now we are coming to misleading ads also. Let me explain all this, then will come how CCPA will work. Misleading advertisement in relation to any product or service means advertisement which falsely describes such product, gives a false guarantee, or likely to mislead the consumer to its nature, substance, quality or quantity of the product and all that, conveys an express or implied representation which, if made by the manufacturer or seller or service provider thereof, would constitute an unfair trade practices, deliberately conceals important information. So what actually misleading is? Misleading is you are giving false information about the product, about its quality, quantity, whatsoever. It is all unfair. As I said, misleading ads started from the Bhupesh Khurana case, and then it was considered that misleading ad is considered as unfair trade practices, and now it has become a part of our act, and misleading ads is considered as unfair trade practices. Now we can come back to our main issue, Central Consumer Protection Authority, how it works. See, is it clear to all of you what is unfair trade practices, what is misleading ad, what is express warranty, and what is product liability? All these four things I would like you to tell me whether you understood this thing, then I'll go ahead. And case law also I have explained, and what was happening before this act came, 2019 act came, and what was happening when 1986 act was in operation. Is it clear to all of you?
Yes, ma'am.
Clear? Any
Yes,
question on this? Then I'll go ahead with the Central Consumer Protection Authority. Could you associate Central Consumer Protection Authority with unfair trade practices? Am I able to convey this message to you that unfair trade practices is a necessary part of Central Consumer Protection Authority, and Central Consumer Protection Authority constituted for various reasons and for due to the various judgments so far had come? Am I clear? Shall I go ahead?
Yes, ma'am.
Ma'am, go ahead. Go ahead.
Okay. So now we are coming to Central Consumer Protection Authority. What type of complaints can be made to Central Consumer Protection Authority? Central Consumer Protection Authority is a regulatory body constituted under the Act, but working under Ministry of Consumer Affairs. So, in practice, I have seen, because in practice, some consumer associations or some consumers come together, they are filing complaints. Individual complaints are generally not accepted for the reason because there should be some prima facie case. Prima facie case is to be there for coming to Consumer Protection Authority, because how we will decide prima facie case? See, there is no mention in the act while constituting Consumer Protection Authority that one should be consumer. One should be consumer who comes to the Consumer Protection Authority. Consumer means the person who pays some consideration, then only he becomes consumer. But for coming to Consumer Protection Authority, this clause is not inserted that one should be consumer. It is written anyone. So if say anyone, so any individual can come, or it is specifically mentioned, state can also refer the matter to CCPA. Central government can also refer the matter to CCPA. Any consumer organization, welfare association can also refer the matter to CCPA. But the condition is, what is necessary is to know prima facie case. Now, how it will be judged that prima facie case is there? If somebody says that in some this in showroom, some purse was lying there and there was no MRP printed over there, so it is misleading. Can it be considered? How can it be considered? Prima facie, how prima facie case will be? It's my understanding, and I have understood through various complaints and this thing. At least someone must have bought the thing. Someone must have paid the consideration. Then only we can say that there is a prima facie case. Someone has actually got a loss. Somebody has suffered the loss. Then only there can be prima facie case. The first thing is there should be violation of consumer rights. There should be unfair trade practice. There should be false, misleading advertisement, false or misleading advertisement, or act. Yes. Anybody wants to say something? Am I audible?
Yes, madam, you are
Audible? Okay. Add prejudicial to interest of the consumer as a class. As a class, whatever unfair trade practices are being followed, the whole class, all the consumers at large are deprived of their rights, then it is totally a class is suffering, class of consumer is suffering, then it becomes unfair trade practices and it becomes a subject of CCPA. Purpose and objective of authority. Now, shall I go to what are the rights of consumers? We can discuss this rights of consumers also. Can you see this on screen? What are the rights of consumers? Can you see on screen? Huh?
No, not yet.
No, then it is with me actually. So, okay, I'll read it out. I'll read it out. What are the rights of consumer? You all know. I think there is. I'm just explaining because it is in the act. I must. But it is the purpose of CCPA to defend the rights of consumers. The right to be informed about quality, quantity, standard, price, manufacturer, and other necessary details consumer ought to know about product or services. This is what it is, right to be informed. You all know what is right to be informed. Consumer must know what product they are purchasing, and about that product, they should have all necessary information. That is what why product liability clause we say if they are informed and if they are not informed. If they are not informed, then it is misleading, whatever the manufacturer or dealer or seller does it. That becomes misleading. So first is to be informed. Then is right to be protected against the marketing of goods, products, or services which are hazardous to the life and property. So if the things are hazardous, they hamper the rights of consumer and they affect their health and properties, etc. That also is infringement of the rights of consumer. So for this purpose also, they can come to Central Consumer Protection Authority. See, whatever I'm discussing, all these subjects are, the subjects are consumer courts. All matters are related to consumer courts. What I am saying, this is the additional system developed by Central Consumer Protection Authority to take care of violation of consumer rights, unfair trade practices, false or misleading advertisement when a class is affected. Before the consumer courts, individual can come or a class action can come and it can be dealt by the courts, and there is a procedure. Total procedure has to be followed, as you know. Total procedure has to be followed and it has to be adjudicated by the judicial body, that is consumer commissions, and they will give their compensation or their loss, whatever they are done, and whatever cost of litigation. Plus now the new clause has also come that whatever incidental loss consumer has suffered, that also can be compensated. That is the court procedure. But before the authority, totality class action to protect the rights of consumers, unfair trade practices, false misleading. For the class, to protect the rights of class, it is not judicial body. It doesn't adjudicate the matter. It does not compensate, but it takes action as per the law provided in the Act, and Ministry takes up under CCPA, Central Consumer Protection Authority. It's a body, it's a regulatory body which regulates the market in the interest of consumers. It's not adjudicating body. There are questions. Do they overpower each other, or their rights are overlapped or something? That is a different subject. It is not. It is totally separate, this thing. So what we are talking about now, rights to be protected against hazardous things. Right to be heard about the grievance by the seller. See, right to be heard, actually it is before you. Before all the courts, people are coming with their right to be heard. But apart from that, there is a right to be heard before the manufacturer also. They should have service center also. There should be care centers, and care centers also should listen to their grievance and redress their grievance. This is actually monitored by a Central Consumer Protection Authority. They see to it that all the manufacturers have their service center. They redress the grievance of the consumer. If they're not doing, they can be called. Now I'll come to the action, what action authority can take up. There I will come with that issue at the later stage. Let us first complete this. Now fourth is right to choice and to be assured wherever access to the variety of goods, products or services at competitive prices. This is right to choice. When a consumer can choose this thing or that thing. Again, I say, what are the incidents? Incidents are buy one, get one free. One thing, you have to buy your this gas oven also or gas stove also if you want gas connection. So these are the things unfair observed by the authorities that it is happening. One should have the choice. One wants to buy this thing, they will buy one this thing. Not that you can buy this thing and along with that you have to buy this thing. These are the practices happening in the market. How to curb that practice? This is CCPA. This is the authority which monitors all the things. The right to seek redressal against unfair trade practices or restrictive trade practices or unscrupulous exploitation of consumer. This is the basic basic purpose of CCPA. And lastly, the right to consumer awareness and education. This is very important to know. We are talking about all the rights, but we are not talking about the education, educating the consumers. This is the actual responsibility burden by CCPA in their purposes. What is the purpose of CCPA? What they can do and what should they do in their monitoring the consumers' interest and all that. So I'm coming to that now. Prevent the rights of consumers. We were here. Now, prevent unfair trade practices as ensure fair and deal to consumers. Unfair, we are talking about unfair only since we have started this session. So it is, they have to ensure that no unfair trade practices are prevailing in the society and consumers are not deprived of their rights. False or misleading advertisement is made of any goods or services which contravenes the provisions of this act or the rules. So what is unfair and misleading? We have already talked about it. Misleading means which leads to misguide you, leads to take you somewhere which is not actually correct, but you are convinced that this is what is correct and they are giving the statement that is misleading. Now, what are the action authority has to take up? Authority has to inquire or investigate either suo motu or on a complaint received or on the direction from the central government. Suo motu, they can take up the case. Why? Earlier, I said there was no provision. There is no provision in the Consumer Protection Act, and there is no power to the consumer commissions to take up suo motu investigation. If there is a complaint filed before the commissions, they are adjudicated through the total process which is prescribed in the Act. And after the order is passed, consumer is left with the opposite party if they implement. If they don't implement, consumer has a right to come to that particular forum or commission and say file an execution petition. Execution petition, if filed, fine, then consumer court will try that all the orders whatever are passed by the consumer forum or commission, sorry, now it is commission, they are implemented. There can be a process followed. They are summoned. They are issued notice. You all know notice, then bailable warrant, then non-bailable warrant, and then declaring, expounding. All this process is taken, as you understand. But if person does not come for implementation of their order, because in most of the misleading ads matters, trader or manufacturer, they immediately comply the order for the reason that they give them compensation whatever has been ordered, but they do continue with the publication of the same order, same misleading ad. Because of this reason, now inquiry or investigation is done by CCPA suo motu also. On a complaint, pardon? On a complaint received or on a direction from the central government.
Okay.
Central government can also give direction or complaint can be. Yes.
Everyone to please have your mic on mute, please.
Please, Sarojat ma'am, somebody wants to ask something?
No, I'm just requesting them to have their mics on mute.
Mic is on?
No, I'm requesting them to have their mics on mute.
Mute?
Yes. எல்லாரும் கொஞ்சம் mic mute பண்ணிடுங்க sir, please.
Okay, some people have not done mute.
their mics.
Okay.
Yes,
okay.
yes. Yeah,
Okay,
yeah.
okay, it's okay.
Please go
Okay.
ahead, ma'am. Thank you, thank you.
Okay,
Yeah.
okay.
Sorry to have interrupted. Yeah.
Because whatever they are talking, I can listen to that. Okay. Action by the authority. Now, next action is file complaints before the district commission, the state commission, or the national commission, as the case may be. This CCPA has the authority to file case before the courts, before the commissions also. They can also file the complaints if they find there is unfair trade practices going on somewhere. As a class action, they can also file before the district commission, state commission, or national commission. That also authority can do it. Intervene in any proceedings before the district commission or the state commission or the national commission in respect of any allegations of violation of consumer rights or unfair trade practices. Supposing there is some case going on and CCPA has got some more material, more information, or more knowledge, or some more people have come to them and explained that this is the case going on before the commissions, they can intervene also. They can intervene, they can give their feedback, they can put their information to the court and give the court necessary assistance to go with the case much better way. That also CCPA can do it. Recommend adoption of international convenience and best international practices on consumer rights to ensure effective enforcement of consumer rights. This is, since we didn't have any regulatory body, consumer forums, commissions were working their own, whatever complaints are coming to them, they were adjudicating it. Now, this regulatory authority can regulate many things. International practices, whatever they are to protect the consumer rights, they can adapt and they can work on this and regulate and monitor all such things also on their own. This is their power, they can do it. Undertake and promote research in the field of consumers' rights. This is very important thing. Whatever research work is going on in the country, workshops are conducted, books are published, libraries are developed, and so many things are done in the line of research work. All is to be monitored by the CCPA now, and CCPA can do all these acts, whatever were not done by the consumer forums. So this is the actually activities to be done by authority, and this is the face of all consumer unfair trade practices. Again, I have actually, these are. Then encourage non-government organization and other institutions working in the field of consumer rights to cooperate and work with consumer protection agencies. This is also the objective of CCPA. Why I'm relating now CCPA activities to unfair trade practices? Because basic concept is that unfair trade practices going on in the field and the market cannot be curbed suo moto by the courts. Courts can adjudicate the matter which comes before them. They can follow the process and adjudicate the matter and give relief to the consumers by way of compensating them with their loss or with the cost of litigation or incidental losses. Now also they can be compensated, but other things in the market, those who are not coming before the courts, every consumer cannot come before the court for the interest of consumer, to protect the consumer rights. CCPA has to work basically on unfair trade practices, misleading ads, and to protect the consumer's right. This is what actually is all about consumer unfair trade practices in the Consumer Protection Act. Now I can, you can ask your questions or we can discuss on any issues. Please come ahead with your questions. Yes, and you can unmute now your mics and ask any questions. Or we can discuss. Actually, it is with you. It is an interaction and we exchange session. It's not a workshop like layman's this thing. You can discuss whatever your experience. You can share your experiences also with me, and I can be also. I should also be benefited with your experiences. Unfortunately, we are not in interactive session directly. This thing, and even I don't know the names also. Whatever. So. Do you find something to be asked or to be discussed or share your experiences? What you have to ask me. I'm no one to reply you. You are the judicial persons and your legal luminaries. So, but you can also share your experiences with me. Anyone?
Any questions, sir?
Yeah.
Madam, any questions? So, Dr. Premlata, maybe you could start by sharing a couple of your experiences as a member.
Yes, I can. Yes, I can. I
That
can, but I just want your permission because so many, judicial persons are there. The judges of the country are before me. So I would like you also share your experiences, but I can share my experiences. See, sometimes, judges have to go out of box also to do justice, whereas there is no provision of such that you can do it. So I'm sharing one experience. At one stage, uh, in my, when I was in Janakpuri Consumer Forum, at that time, the whole, we were in community center, that market people came to us and said, if for the last 30 days, there is no water in our shops because someone has not paid bills to Jal board for so long and they are not listening to, and they have stopped paying and they have stopped giving water to all of us. So what can be done? So we thought, my colleagues also, we thought what can be done if you are not paid, somebody has not paid, you press on them that they should pay the water bill and it will be okay. But it could not be done. They said there is some officer sitting on the file. He is not allowing anyone to move that file. So this is what has happened. So it was not in our this thing to do anything drastic. But my friend, that judge, he was retired judge from the district court. He said, let us do something. So I was a bit reluctant, but he said, no, let us do one thing. We passed an order that within 48 hours, water should be given to all the shopkeepers, those who are suffering without water. You can put penalty on those who are not paying the bill. You can put penalty or you can disconnect, but why you have disconnected water for the whole this thing market? So within 48 hours, water should come to all those, failing which per day salary per day such amount 100 1000 or something, it is 2001 matter, 1000 or something more than 1000 I think should be deducted from the salary of the person who is to deal with the file. This is wrong. Actually, it was not correct order. How can you make such order that salary from salary something should be deducted? I was a bit reluctant, but he said, let it be passed. Let it be passed and it will be done. Nobody would like to salary to be deducted, but it is wrong. Okay, what he said is we are legally authorized to make illegal orders. It's I'm sharing experience. He told me we are legally authorized to make illegal orders because there is a other next door to them. They can go to the state commission. By the time state commission, they will go to state commission. By the time case will be accepted, and by the time things it is admitted, this order will be implemented. You will see within 24 hours, water was released to all the shopkeepers. Now this is going out of the box. Okay, some error has happened, some mistake has done. State commission will correct this thing. So this is what sometimes the things it cannot be this way, but there are ways how to give actual justice. This is what has actually my experience, but may not be a good experience. I'll share one more experience with you. Then once, there was medical negligence case. That some colonel or some army man was there, and he came, filed on behalf of his wife. He said that one breast is shorter, so they went for cosmetic surgery, and after that surgery, a lot of pain has been suffered by the wife, and they filed medical negligence case before that. And that colonel, that army man, he himself was a doctor. He brought so many medical literature and medical established norms and brought before us. Case was finally at final stage, and at final stage, when the other party came, they said ki this was operated and there was a lot of problem, and we went to other doctor and they operated. Now she is all right. So this is the medical negligence on the part of first doctor who operated my wife, and she suffered a lot, and it was wrong procedure followed by that doctor. Okay, but at the last stage of argument, what came out, the first party said, opposite party said, they did not disclose the material fact before us that there was cancer to this lady, and cancer was treated, and after treating the cancer, again they went for cosmetic surgery, and they did not reveal it. If there was a cancer, there was a different procedure to be followed. There was some different type of padding and something. Tissues are to be revived first. That procedure is to be followed. After tissues are revived and that procedure is followed, then cosmetic surgery is to be done as per medical practice. They did not disclose this fact, and because of that fact, this happened. And next, when they went to the next doctor, they revealed this fact. That was also made the party, and that party also came, yes, we followed that procedure. So once you hide any important information, last stage, that case was dismissed with cost to the doctor, pay cost for misleading the court. That was one experience I had during my tenure. One more incident was there. There was one garage. There was a case against one workshop. Person came with a complaint that I have paid 10,000 rupees to this garage workshop for, I brought my car and I paid 10,000 rupees. And now after one day only, I went to Agra, and on the way, there was a very big breakdown and my car could not work at all. And I paid 22,000 rupees to this garage. They brought bill also, and they are deficient in providing services. When other party was called, summoned, and they came with the reply. What was the reply file? They said this man had paid 10,000 check to us. We presented the check before the bank and it was bounced back. And we filed the case against this person under section 138 of Negotiable Instrument Act, and he has been summoned. But this man never got done any technical work from our shop. It was only accessories of 10,000 rupees. Roof was, AC was installed, roof was also repaired, and so many other, and seats were also purchased, and so many things were purchased with 10,000 rupees. No mechanical work was done at our shop, and he is lying. This case was also when they brought the notice from the civil court against that man under section 138 of Negotiable Instrument Act. It was self-proved. There was a clause 26 in earlier Act 1986. Now it has been removed. I discussed with ministry also why this clause has been removed. The ministry said we have removed it because every judge has got the discretion to impose any penalty. Why this clause? There was no need of this clause. So we have removed it. There are many other penalties now imposed in our act. So for everything there are penalty clauses. So there is no need of penalty, but there was a clause that you can impose penalty up to 10,000 rupees. So we imposed 10,000 penalty on the person who who gave a false representation and wasted the time of the court. So these are my experiences. I would like you all to share your experiences. I would like to know.
Madam, one question.
Yes, please.
Madam, it's regarding the NCLT proceedings. It will pass the consumer NCLT. Any resolution process has been taken.
Shivkumarji, I am not able to hear you properly. Yes.
This is regarding the NCLT under IBC Act.
IBC Act?
NCLT.
NC?
NCLT.
NCLT, yes, tell me.
Yes. The order, the resolution process has been passed. The Consumer Commission from proceeding further.
Company Law Board, you mean? Company Law Board? Tribunal Company Law Board?
Yes, National Company Law Tribunal.
Yes.
Yes, whether it will, the order passed the NCLT will allow the consumer to proceed, Consumer Commission.
Voice is not clear, sir. It's breaking actually.
Not getting your point. I understand the national this tribunal is also working a lot for giving relief to the consumers when they are coming before the tribunal. I have not got your point, but what I know is happening is that these tribunal are also giving relief when people are going to before them for this thing insolvency proceedings, for initiating insolvency proceedings. They are actually giving relief. Companies are coming and giving relief to the consumers by paying them back their dues and saying don't initiate these proceedings. I am not able to understand your point, but what point I have got now, recently what is happening, I am telling you.
Can you hear?
Not very clear, actually.
Not very clear. I will just change the system. 1 second.
Okay.
We can take any, sir.
Good evening, madam.
Yes.
This is Shivkumar. I just want to know whether the NCLT order, the resolution process, will restrain the Consumer Commission from proceeding further against the company debtor.
That will be okay. You see, that will be, the court will decide. It is discretion and it will check the facts and all these things. If the question involved is the same and relief is asked the same, then one court can go, both the courts cannot go. As
Some phone sound is hearing. Some phone sound. We can't hear properly. Sorry.
From my side, it is okay. But what I'm saying, okay, try to listen to me. If
Yes.
proceedings are for the same cause, if before the tribunal also, the question is to give money back with interest, and before the National Commission also, the question is to give money back to the consumer. In that case, in one court proceedings can go. There cannot be doubling. You cannot give the case cannot go before both the case. But if reason is different, like if it is deficiency in services before the commission and there is a recovery suit in civil court, both can go depending upon the case and relief sought. Very important is what is the relief sought, what is the prayer part. If prayer part is the same, two courts cannot go together with the same. That is the fundamental principle of law.
By the order of the court, we come to know that against the natural person, that is against the directors, we can proceed, though the NCLT order has been passed. Is it right? We cannot proceed against the company debtor, which is under revival. Is it clear, madam?
No, what I understood that before the tribunal, you have got filed cases against directors also, because that is company law matter. So directors are also implicated in that case. But in National Commission, it is not. Now again, it is a choice of the consumer which to opt for. One case has to be withdrawn. One case has to be either sanitized till order is made. Both cannot go together. See, this theory of both going together, I am giving you one example. There was a Bombay brasserie case where the case was filed against the hotel saying that my vehicle has been stolen from your hotel, and at the same time they received damages from the claim from insurance company. 2,50,000 claim they got for insurance company. Now the court said you cannot be benefited from both the sides. 2,50,000 was deducted and rest was paid by the hotel, not all. Theory is actually basic law is you cannot be both benefited by both the sides. One has to be. If you want to pursue against the director, you pursue it and leave National Commission. And if you want to get your money, your basic interest is to get your money with interest, and you are to be, compensated for your losses. It is your choice. One has to be stopped.
Yes, madam. One final question.
Yes.
This is regarding unfair trade practice and misleading ads.
Yes.
Actually, can be termed the product provider or the service provider offers any special offer or something.
Yes.
If they deny to give that offer, can we term it as misleading ad also?
It is misleading. It is unfair trade practices also. This is a special clause done in that. What they say is buy one get one free. They never get, they gave one free, they gave, but buy this item, you will get iron, you will get this gift, and they never give gift. What happens? What happens? I'm telling you. What happens? They say today it is not there. Stock is over. Tomorrow you come. Tomorrow, day after tomorrow, weeks, and after months, that item is not given. See, for that reason, you need to know many other customers also who are involved and who are not given. This is a strategy. They never want to give the gifts, and you be together. Collect, make one application and file it to CCPA. CCPA will not pay you damages because it is not a code. They cannot adjudicate case. But at a class, in totality, class action shall be taken. And I have not taken much in my representation. CCPA has got the power to seize their product, to seal their premises, to call them, and more than 50 lakhs they can impose cost for small thing. It's not a matter of money. It is matter of unfair trade practices which is going on, and many are suffering. Many other consumers are suffering. Many consumers are suffering. One consumer is going to consumer court and is compensated or adjudicated their matter, or they got relief from the court. But what about others? Yes, you can always go. It is unfair trade practices also and misleading ad also. Both.
Thanks, madam. Thanks.
I have a good question, ma'am.
Yes, please.
One doubt. Yes. We have a case in Sarfasi. It is in continuation of the earlier question. Where the company law board has passed an order, stay order, in the insolvency proceedings against opposite parties. Whether the outfall that stay order is binding on the consumer forums.
What I have understood,
Insolvency
order has been, if some order, this is what as my experience, when order has been passed by the commission, okay, it has been stayed saying that company has got insolvency. Am I right?
Yes.
Am I right? Okay. Okay. See, if proceedings have not initiated, then there can be a stay. But if order has been passed, that order becomes final. Now he is entitled to get that money which has been ordered. So it becomes a part that even if it is going insolvency, so whatever company law board makes a list, this is also part of that list that he should be paid. That execution cannot be stopped at this stage, but it could be stopped before initiating. That whatever amount or whatever problem they have got, they can go to the company law board and enlist themselves that this is my dues I can take. But if order has been passed at that stage, execution cannot be stopped for execution. Either it is to be executed by the court, or sometimes they say come with a list, we are paying to all in installments. That is the choice of the consumer, because it is consumer to choose the way in installments they will be paid, or they want execution. At this stage, execution cannot be stopped.
The case I am referring is we have not disclosed that case. State case is still pending. The complaint is still pending with the commission. Meantime, the company law board passes an order in the insolvency proceedings for stay of all proceedings before the forums throughout India, pan India.
See, if there is a list, if they have gone to insolvency and there is some process going on, company law board is deciding these are the actually creditors, they can go and enlist them with the creditors. So some way they have to get their money, either this way or that way. It cannot be left in this thing that they cannot do it. It cannot be that.
But the issue is completely different. Here the issue is based on a deficiency in service. Whereas the company law board is issues entirely different. How we can claim that there is a list pending before the commission? That is a company law board. Because the issue before this commission is whether there is a deficiency in service or not. How far that order is binding on us?
I do not know, but because that order must be specific. Why? There must be some reasoning given by that. Court has passed the order to stay it because party has gone to insolvency. If order has not been passed, then it is right. What I say is, if order has already been passed by the commission or by the any commission, then it is final. It has become due now, final. But if proceedings are going on, then there can be an order. That is what I said.
Okay. So I got another issue. In case if there is an unfair trade practice or a misleading advertisement which affects the consumers at large, it is not confined to particular place.
Right.
It affects the entire pan India. Whether the commission can refer, a district commission can refer the complaint to the CCPA, Central Authority for Investigation.
No, Consumer Commission will not refer. Consumer Commission or state or center or any organization can refer the matter to CCPA, and CCPA has also got the right to refer it to the court, commission, to you people. They can, CCPA can also come to commission, and
Whether
that
the
will be
commission can direct for investigation. We are asking whether we can direct the authority to investigate that matter.
Not directing authority, not at all directing authority. They come before you with a plea, with a prayer, sir.
Correct. But we feel
not
that
direction. There cannot be any direction by CCPA to any commission adjudicate it. It will be proper application, proper complaint made by CCPA. CCPA can be an authority or can be a representing authority before the court. Not. That is what I said. People are always saying there can be overriding this thing. It is not. CCPA is not adjudicatory authority. It is only a regulatory body. They can come with the proper complaint as consumers are coming together. If class action is coming to you, it is like that only. Class action they can make a complaint, they can make a proper prayer, and they can come before you on behalf of consumers. Please educate it.
They have the power to investigate. They have
got the power to, that is the different procedure. They have got the power to investigate. But I'm saying, okay, how consumer CCPA acts when there is a prima facie case before the commission. What they do, they send, they call the complainant. If they have got further investigation, any material with you or any evidence with you, please provide. After they provide or before they provide, CCPA can send that application and that refer to the concerned regulatory body. Like if it is medical negligence case, they can give to Medical Council of India, investigate this matter and give back us a report. Regulatory body, supposing there is some matter relating to testing, they can give it to NABL. Please get it tested from your labs and give us a report. When report is given to CCPA, on the basis of the report, they can take up action against that particular enterprise, or they can investigate themselves also. Both the parts CCP has got. CCP has got very vast powers. This is separate from your courts. Commission has to work on particular case, but they have to work at large. They have got investigating authority themselves, and they can, I told you, they investigate the matter, they seize their premises, they call their documents, they check every damn thing, and they can impose up to 50 lakh rupees and this thing punishment, sent to jail also, that is provided in that. I didn't bring it because I thought you have got acts with you can check it. Investigation authority they have got separate wing to investigate. That is not related to consumer commissions. Consumer commissions are judiciary body. They independently work and they investigate separately. And if investigation is taken up, that is not judicial. No consumer will be benefited by that. Monetarily,
As per section
no
90,
compensation by CCPA. It is
as per
only.
section 90, ma'am, as per section 90,
Huh?
the CCPA can gather information from even otherwise.
Yes,
Or
they
receives
can.
a complaint, or receives a
You,
complaint.
me, anybody. You, me, anybody. They can call and get
Anybody.
investigation.
So in that
from
case,
anywhere.
what we cannot direct or we cannot refer that. Whether
Pardon?
we can refer that matter, the complaint for investigation.
Pardon?
One doubt regarding SARFAESI proceedings.
Huh?
There is a pending SARFAESI proceedings.
What
Under
is
the
that?
SARFAESI Act, we cannot, other courts do not have jurisdiction, especially civil courts.
Huh?
Do consumer courts have parallel jurisdiction? We are being approached by the auction purchaser, alleging deficiency in service against the bank because there is litigation and there is no possibility of getting back his money. So can we take it up? Do we have the authority to do that?
Yes, you can do. You can do. It is your choice where to go. When you find that you don't have that particular material or evidence with you, and you cannot support your case in the consumer court, you tell the authority. Authority will do it. Authority will find out, not from you, from others also.
No, madam. What I'm
they
saying
can
is,
take help of regulatory body, particular regulatory body. They can go into details. Too many details they can find out. From many consumers also they can find out.
No, madam, I have not made myself clear. What I wanted to say is, when there is a case before the SARFAESI authority, and the SARFAESI...
Which authority?
DRT, madam.
Can I interrupt?
Here?
Can I interrupt?
I do not know what.
Can I interrupt? Can I interrupt?
Yes, please. In some authority, before some authority, no.
Section 34, Section 34 of SARFAESI Act bars. It's a special for enactment, so you cannot proceed.
No,
exactly. That's why I wanted to ask.
See, one thing.
You have only to civil courts. There is no special bar to consumer courts.
You have to adopt one way. You have to
No,
adopt
it also says about the proceedings.
You have to
Even the consumer court cannot proceed.
You
To my
cannot
knowledge.
proceed to two places. You cannot proceed, and it will interfere in one other thing. See, I am telling you one example. See, for RTI, there were many questions initially, many cases initially. That RTI, I filed a complaint before the RTI. RTI has not given me reply. Now, can I go to consumer court? Initially, I was also thinking, why can't? Because giving information is also service. So why it can't be in service, deficiency in service? I was also of the opinion. But then I read a lot and did a research. See, RTI is one act. If you have proceeded with one act and you have filed complaint under one act, so if this district level or lower level does not listen to you or does not do anything, you can go to the tribunal next to that, not come to consumer forum.
You mean to say it is barred by res judicata?
Because you have chosen RTI. See, one system you have adopted. You have to go in appeal to the next system. You cannot deviate to other system.
You mean to say it is barred by res judicata?
I'm not getting your point.
Proceedings.
Pardon?
Are you saying it is barred by res judicata? We cannot have parallel proceedings.
The res judicata is something different. res judicata is when one case has been ordered. Res judicata means one order has been passed, one mainly and mostly it happens with the Workmen Compensation Act. What happens in the factory? This somebody is disabled due to this accident, and management order has been made that management should pay this much compensation. So for similar type of order, res judicata will apply. Res judicata is different thing. Res judicata is one order has been passed, similar circumstances under similar with the similar parties. It can be the res judicata is different thing.
No, but we cannot have parallel proceedings in different forums. That is what you are trying to say.
I always say parallel proceedings cannot be there in two forums. If somebody comes with this thing, you have to inform the other court that similar with a similar prayer, with a similar relief, you cannot go to two established whatever judicial system or administrative system. You cannot.
Thank you, madam. Thank you.
Madam, one more request. Can you hear me? Can you hear?
Yes, yes.
One request.
Yes.
Madam, ex-member of Consumer Commission Delhi. Madam would have come across many mediclaim cases.
Mediclaim cases? Yes. Tell me. Very interesting subject. Very interesting.
Mediclaim cases, most of the insurance company are not advertising that if there is any pre-existing diseases are there, they have to wait for certain period and some other things they mention.
Yes.
They also give a look-in period for 15 days to accept the terms and conditions of the policy.
Shall I come? Shall I come? It's very interesting. And
Yes,
I'm working on it day and night. Achha, I didn't tell you. I have got a YouTube channel named Consumer Awakening Mission. That is my YouTube channel, and there are more than 556, around 600 videos. Not even a single subject on Consumer Protection Act is left. Even on medical negligence, there are 15 to 20 videos on it. I have sent one, I have given one video to Saroja ma'am. It is about why consumer courts are becoming civil courts. So I have analyzed and done research on that. That video I have given, she will share with your state commission, and you may get it. And one more presentation I have given, which was not my subject. It was when this how this Consumer Protection Act 2019, what are the changes made in this and why they have made. Because I have given reasons, but I have been discussing with you what happened and what for this process come. So that also I have shared with Saroja ji. She will share it with your state commission. They will do. Now I am coming to pre-existing disease. See, pre-existing disease is exclusive clause in their this thing. Various insurance companies have got various clauses depending upon whatever they have decided. Mostly what is pre-existing disease is non-disclosure of material fact. Yes. This term is not there in their insurance law. It has not been explained in insurance law, but Supreme Court in various judgments have explained this clause, what is non-disclosure of material fact. What they say, whatever small thing has happened, they say it is non-disclosure. What criteria Supreme Court has decided in Asha Rani Agarwal versus Life Insurance Corporation. This case was decided once in 2000 and then 2009 Supreme Court. Please note it down. 2009 Supreme Court case. This is Asha Rani Agarwal versus LIC. Criteria has been decided by the Supreme Court. Non-disclosure of what is non-disclosure of material fact. First thing, there should be some non-disclosure of some fact. This should be the first thing. Secondly, the fact which has been not disclosed should be so material that if known to insurance company would have not issued insurance policy. So it is very, very important whether this information which has not been disclosed is material. In some cases, I'm stopping here. In some cases, did you have more policies, insurance policies? They said, okay, yes, we had. So, why you didn't tell us? No, this dismissed because it's non-disclosure. So such cases are coming before me. You know, people are actually. I'm giving Sunday live question answers to general public at large. They are asking me question on my WhatsApp throughout the week, and I'm answering them on Sunday live at 6 o'clock, their queries. So I know a lot about what is happening in the world, in the our country. So next is, it is not material fact. It is not at all material fact. If insurance company would have come to know that they have got more policies, they wouldn't have stopped giving issuing this thing. So it is not material fact. Third is the fact it has not been disclosed. Was it known to the person? Was it known to the person who has filled the proposal form? So that is also one question. It was not known to the person. I am telling you one very good example and one very experience and case. There was a case in 2002. 2002, I was in Janakpuri in Delhi Consumer Forum. So the case was that some patient goes to the hospital and they say, what are this problem? How long you had this problem? That breathing problem. They said this breathing problem was for the last 2-3 years. It is happening with me. So breathing problem is a symptom which can be for many reasons, not for heart problem only. So he disclosed this, and it was this thing. This case went up to Supreme Court. They wrote it for the last 3 years. Okay. When ultimately they came for claim, they said that this problem he was having for the last 3 years. It is written in the discharge summary, because at the time of admission in the hospital, it was noted down by the clerk. This man said, for the last 3 years, I am having this problem. That clerk wrote it down, and in summary procedure, in discharge summary also, it was noted. That case was escorts. At that time, Dr. Trehan was there in charge in escorts. So that case came to us, and they said, last 3 years, the patient went to the doctor, to Trehan, Dr. Trehan. I didn't have any problem for the last 3 years. I just said ki breathing problem, maybe by age or climbing stairs and all that. But I never had any problem. I never consulted any doctor. So the criteria what is that one should have consulted the doctor, taken some medicines, must be hospitalized, or it should be cogent evidence on record that he had really taken medicine for this particular this thing. Not that it was in this thing. Now this case, he went to doctor, and doctor improved it, and he said it is not for the last 3 years. It is only, he reported us, we diagnosed it only on that day. So it should be considered the day he came to us, and why we diagnosed it. Angiography was done, and we diagnosed it from that. So for that, our treatment, he should be paid. Now there was an allegation against Dr. Trehan also. They said that Dr. Trehan malafide intention say he has changed this report. This case went up to Supreme Court, and Supreme Court ultimately held that it should not be considered the fact which patient discloses at the time of admission in the court. There should be cogent evidence that the person had been treated, had been consulted by some doctor, doctor has prescribed some medicines have been taken, and then only insurance company can say that it was pre-existing disease, and onus lies on the insurance company to prove it through cogent evidence from their investigation, their papers, and show it that they have investigated and they had found it. It is not the consumer to prove it that it was not in this case. That is one thing. But fraud cases are to be proved by the person against whom allegations are there. If due to fraud there is a cancellation of insurance policy, then it is the person who has been insured is to prove, yes, I have not done any fraud.
No, for that, madam.
And yes.
Regarding that fraud you are mentioning.
Yes, that the consumer has to prove it.
Nowadays, the insurance company is taking a trump card. The recordings that they have made initially, the recordings with the consumer, with the insured. They are producing the recording wherein the insured states that they don't have any pre-existing disease. Will it amounts to a fraud?
No, what is fraud? What is fraud? What is fraud? See, I'm giving actually live chats every week. every week. Recently I've done it. So I'm telling you, fraud is giving misstatement, not concealing, not concealing the fact. It is misstatement. Some wrong statement given, misled the insurance company. Yes, it is a fraud. If some wrong information is given, misleading information is, then it is a fraud. And silent. There is again a question. Again, there are questions that if person is silent, does not give any information, will it amount to fraud? No, not in all cases. If it is silent and very important information somebody is asking and they're not giving, then it is fraud. But just keeping silent does not always amount to fraud.
One more request for your consideration.
Yes.
Why nowadays the insurance company is not doing medical checkup to the insured?
Insured, yes. In house loan cases. Mostly in house loan cases.
Initially, the insurance companies used to check the insured through their doctors to find out what are the disease they face.
Yes.
Or in their existing in their body. Why nowadays, even for the mediclaim, the insurance company is not showing any interest to check the insured.
See,
this
for
may,
mediclaim,
this may avoid the after taking
claim.
up the policy to share the there are pre-existing disease.
Yes, claim, just to reject the claim.
Why the insurance company is not taking the insured to medical checkup?
See, more than 7,50,000, they are bound to get checked. It is mostly in home loan cases. In home loan cases and compulsory insurance is given. In that case, it is the responsibility of the insurance company to get it checked. And there are Supreme Court orders that if company has avoided doing this, then they are liable to pay the claim. Supreme Court order says this. If more than 7.50 lakhs is involved matter in loan cases, they have to take. And if they have not done, supposing it is their rule, see their rules. If their rules that they have to get medical checkup done and they have not done, they repeat routinely they do it. But you can go to the court. Supreme Court says, I have got cases. I've got this. You can search my videos, Consumer Awakening Mission. You will find many videos on these issues also, and every issue I have given citations also. So they can. But in mediclaim cases, they are not bound to take this medical this thing. It is only your declaration. In mediclaim cases, it is your declaration proposal form. Mostly people, what say they? In proposal form, we didn't feel anything. Agent said, "Aap tick kar dijiye." I have done tick without reading it. If without reading you have ticked, but you have signed it, it is your declaration. For mediclaim, you have to declare. For house loan, where rule is prescribed that they have to take medical test, it is their responsibility. If they have not taken their responsibility, they have not followed their own rule, then they are liable to pay claim.
So I want it to be a request to madam to make it as a rule to the mediclaim policy also. My request to madam is to take up the issue to make it as a rule to the mediclaim also.
That is actually IRDA to do. You can write to IRDA. As a judge, you can write to IRDA that make this also. But but I see mediclaim policies are 1 month for 1 year. For 1 year you pay premium, and after the 1 year, if it lapses and there is no disease, it lapses. So that mediclaim, the proposal form what has been made, there is not compulsion of taking medical test by the insurance company. But if you feel it should be done, you can write to IRDA and revise that this thing. The way I told you, Dr. Trehan's case, they are modified. You know what they did? Well, earlier they were not sending rules and terms and conditions along with the proposal form. The proposal form, then there were orders. The Supreme Court also said there were orders when the terms and conditions are not provided at the time of proposal form, that consumer is not bound by that clauses which you have not disclosed. Now with the proposal form, they have amended. I was in the meeting when I was called by IRDA and insurance, many companies, and we discussed this thing. If you mean that you want that these terms should be followed, they should be first disclosed and it should be signed at the proper time of proposal form. Earlier proposal form never had these terms and conditions. Now with the proposal form, these terms and conditions are enclosed after that. Say 2004 or 2005, when we discussed, as you judges, I am suggesting you as judges, you have got the right to call some agencies like insurance. If you find some lapses in this thing and you're finding some complaints are coming of such nature, you can invite them for discussion and say, do this thing. Otherwise, such cases will go on like this and it will go against you. So we also did this way. There was a meeting with the insurance company. There was meeting with the real estate matters. There was a meeting with all other agencies, those who are actually, we talked with all agencies and we suggested them, and that took it and considered it, and they made it form of part of proposal form. So what you're saying, it should be, I don't think it will be necessary. I think it will be too much for them. But in house loan cases, there is a rule that they have to take test. They have to conduct test in their own, under their own supervision and in their own premises and in your under their this thing. So they are doing it. They're doing where they're not doing it, but still rejecting. They are caught because we are making orders, and I'm suggesting, I'm giving order copies and citation to all consumers every day. I'm doing it. Every Sunday I am telling them, and they write us, so then I provide them citations also. So I have got plenty of videos for more than about 6,600 videos. I'll be very happy and glad if you see them. And many newcomers, members are my members also. They are writing to me, they are asking me, and their presidents are surprised. Presidents is, how this lady, she didn't know anything and now she's speaking so much and interacting with the consumers. What is the reason? They said, I have not, I mean, it will be too much to say, but they said, we see Consumer Awakening Mission's videos that explain us the law, and we are benefited by that. So you also please give me ideas. What is your experiences, what I should do, and how I should help the consumers with your help. You are judicial persons, you are judges of the country, and you can always help me and suggest me and guide me and direct me how I should do, and what are the more things I can do for the consumers at large. Thank you very much.
Thanks a lot, madam. Thanks a lot, madam.
Thank you very much. Thank you. And it was very interactive session. More than what I said, I think we have discussed much more than what we discussed through our this thing. I wanted this actually. Thank you so much. Thank you.
Thank
So,
Thank you very much, ma'am,
can
for
I
being
take
here
leave?
today.
Okay. Okay, ma'am. Saroja ma'am, thank you so much.
Thank you. Thank you, ma'am. Thank you all.
Thanks a lot, Saroja, madam.
Yeah, thank you, sir. Thank you.
Thank you.
Yeah.
Thank you, everybody.
Thank you, ma'am.
So, yeah, we'll meet tomorrow. Thank you.
இருந்தோம் நம்மளை காமிச்சாச்சு நம்மளும் இருந்தோம்னு